Nigeria's anti-corruption war might have just gotten a boost. Now, this is as the Chief Justice of Nigeria, Justice Walter Onogen, has ordered all heads of courts in the country to designate 1 or 2 courts in their jurisdiction as special courts for the hearing and speedy determination of corruption and financial cases.
Well, Justice Onogen also directed them to compile and forward the list of all corruption and financial crimes cases in their courts. He said a committee would be set up to effectively monitor and even enforce the new policy and to ensure that both the trial and appellate courts handling corruption and financial crime cases key into and abide by the renewed efforts at ridding the country of corruption.
The CJN also directed all heads of courts to clamp down on lawyers who deploy delay tactics in criminal matters before them. Well, we'll be discussing this with our guest who is joining us via phone. He's a constitutional lawyer, Olanrewaju Ajanoku. Good morning and thanks for joining us.
Good morning.
Yes, now this plan for special courts, special anti-corruption courts that the CJN Walter Onogen has announced. Is this the way that Nigeria needs to fight corruption to a standstill?
Well, yes. I would not say is it the way. It is one of the ways to fight corruption. If we are in a state wherein the dispensation of justice in matters related to financial crimes could be sorted out within 3 to 6 months, and it is seen that justice is manifestly done. I want to believe that the moment you have people who have gone through the rigors of trial and have seen and well seen by everybody that justice was done in that matter, people will somehow begin to behave normally and not abnormally when it relates to issues of finance.
Looking at some of the measures suggested by the CJN, will it work? Weekly adjudication of corruption cases in the country?
Yes, sincerely, I think it is the right path to go. What the Honorable Chief Justice of Nigeria has done will whittle down on the time in dispensation of matters of this nature. No matter who you are, no matter who your representative is, and I'm talking in terms of the lawyer representing you, no matter how highly placed you are in the society, one thing for sure is this, that within 3 to 6 months, as has been done in other climes, well-developed climes abroad, you will realize that justice will be done within a very short period of time.
Speaking of that,
all over the country, in every state of the country.
Now, according to the CJN, let me quote him, inexplicable and intractable delays have been the bane of criminal justice administration in the country. Now, the Administration of Justice Criminal Act, ACJA,
yes.
Are we saying this has not been effective since it's been put in place?
Well, yes. See, the purpose of the coming into place of the Administration of Criminal Justice Act in 2015 was to ensure that indeed procedures or matters of all sorts quickly trashed out in courts. But one thing though is this: the matters that are being tried in court are not just financial crimes matters. You have land matters, you have courts, you have chieftaincy and all that being handled by different judges in different courts. And in all these courts, these are the places where you should take these financial crimes matters to. But what we are saying now is, and what the Chief Justice of Nigeria has done, is to ensure that we have dedicated courts in which financial crimes and other related crimes like that will be tried. And if this one comes into place, we should know that for sure, within as it is done everywhere, you will realize that you will know your case right from the beginning. It is only if you want to go headlong into it that you don't want to exploit the issues of matters that are available in the ACJA on the issue of plea bargain. The moment you see that your matter will be is actually bad from an issue, you want to quickly sort yourself out in this matter. So quick dispensation of justice will get it.
But then what about lawyers who delay cases unnecessarily by filing motions on motions? You
see, one beautiful thing in the ACJA 2015 is this, that matters, motions, objections, preliminary objections, and all other things that you need to raise. The ACJ 2015 has now made it for you to wait till the final determination of the matter before those objections and all other issues will be trashed. Even your appeal, your objections, every other matter you need to raise in that matter will only be appropriately trashed at the end of the day. But people are saying, and people, that's one avenue that people are using to exploit, to say the Constitution is even far above some portions of the ACJA. But we are saying that the ACJA is a procedural law in which you must strictly follow. Not following it will bring in certain things. Well, yes, as you have said, that indeed so many other lawyers are trying to exploit the loopholes in it. But by the time we have the special courts as being enunciated by the Honorable CJN, you will realize that all those loopholes will be, within 3 to 6 months, the matter will be decided one way or the other. And
of course, the CJN has said it will not be business as usual for judicial officers.
Yes.
Let me just put this in perspective. What systems really can be put in place to ensure that the judiciary and the judges actually are above board and incorruptible? Because, I mean, the question is, to what extent really can all of these reforms, especially in fighting the corruption war, succeed without a total overhaul of the Nigerian judiciary?
Yes, well, number one thing is taking care of the judiciary, making judiciary number one priority in this fight against corruption. If this our judges and justices are well taken care of, I want to say clearly that one, they will act above board. Number two, I'm talking about their welfare. Number two, you must have another, will I say, a dog watching the dog? Don't really call them dogs, but we have systems in place wherein those people at the helm of affairs will also be monitored. When they know consciously that they are in fact being monitored, they will behave well, and will have justice at the end of the day.
Some analysts rather are suggesting that corruption cases should be well publicized. For example, like that of Oscar Pistorius in South Africa, where media carried it live, that it should be well publicized. If so, it will go a long way in checking hanky-panky. Do you agree?
I told that line. I agree totally. I told it. It's a good move.
How do you think? Why do you think it's a good move?
See, number one, sometimes, look, when we are in court, you, the litigant and your lawyer will know right in court that your case is bad or that your case is good. One, either through cross-examination of the witness box or through even examination in chief and document or evidence placed before the court. So any other thing that will crop up after will be, I mean, each person, the whole world will know that indeed there must have been an underplay here of something. Maybe something has been suppressed or evidence has been suppressed. You will see, because when a judge who is in the open, the full glare of the whole world, is acting on any particular matter, no matter who the person is, you realize that that judge will be very careful. The judge will want to ensure that justice is done, and no matter who is God. That is what we are saying, that you act well, you act for God. That's what we are saying, sir.
And being very careful seems to be the line that the CJN is towing with an additional anti-corruption cases trial monitoring committee that we hear will be set up to monitor the progress of high-profile criminal and corruption cases.
That was long in coming. I mean, we had expected it, that for us to be seen as being serious in pursuing this anti-corruption campaign and prosecuting the people who have been indicted in this matter, that we needed a committee like that will be able to monitor. You know, I said it earlier, that to monitor the activities in court. And I want to say, without fear, that that at the end of the day, the country will be better for it. We have people, we have eminent judges. We have very good judges and have very good lawyers. But everybody will now have to play the card fairly on the table. That's the way it is.
All right, but some still believe that plea bargaining is still the way to go in fighting corruption, at least for now in the country. Not
totally. I might. You see, I can be your counsel. I'll suggest to you after analyzing your matter, considering saying, I say, look, my brother, my sister, I think we need to explore this issue of plea bargaining. You, as the litigant, might refuse, and you want to say that you don't want to follow suit. You don't want to do any plea bargaining. If I consider that it is, we now have issues pertaining to my advice, professional advice, and you feel otherwise, I might give you your file. So many, but I want to tell you, so many people are exploring that avenue. I have done that several times. I've approached the prosecution to let us sleep again, and they accepted. And that's the way to go. It saves you time, saves you money, it saves you, undue ache at the end of the day. The way it is.
Would it be a fair assessment to say that the judiciary is actually a cog in the wheel of the anti-corruption war?
I'm sorry, I didn't get that.
Would it be a fair assessment to say that the judiciary is actually the problem when it comes to fighting corruption in Nigeria?
Oh, no. Judiciary is not totally the problem. You see, why some people do say it's the judiciary is because of the time frame, and some people will say, well, yes, they are well connected to certain people and they can tilt judgment in their favor. Well, no, but certainly not. We have to also look at even the investigators of financial crimes. Have the investigators done their bit in ensuring that no loophole is left unplugged? Have they done the very utmost discreet investigations in matters of this nature? Because if they are high profile, those people who are indicted will ensure that they get the best of the best to come for them in their defense.
But then, Ajanaku, prosecution teams in the past have lost many good cases due to technicalities.
You see, the technicality is no longer the way to go now. Substantial justice is the way. We have said that just like Lord Denning did in that time, in his time, he used a law as a social engineering tool. We, the judges, should also be able to stay above board. Don't do justice, no matter whose ox is God. That's what we are saying. If
all right.
We have judges that are well backed.
Olariwaju, we'll have to end it there. Thank you very much for your analysis at this time. Thank you very much, Olariwaju Ajanaku. Thank you for your analysis on the show. This time, you're a legal practitioner.